Dean Faculty. Now, how are we doing for time, Dean?
My Lord, my Lady, I don't anticipate being very much longer, subject to any points that may be raised by the court. And indeed, I would anticipate, and it's a dangerous thing to do in these circumstances, being about 15 or 20 minutes at most.
We'll not hold you to that, absolutely, if we interrupt you, Dean Faculty. Yes, thank you.
I'm obliged. Lords, my Lady, we touched upon the opinion of the Inner House briefly this morning, and it is to be found at tab 2 of the core volume. And we looked at paragraphs 44 to 47. While the Inner House considered that the plain meaning of section 29, subsection 3, is that Parliament intended any member of the public who suffers any damage or injury to be entitled to raise an action for damages, founding that action upon a breach of statutory duty, I would submit that no such plain meaning can be found on the face of the Act itself. Whether it's intended by plain to be express or to be a necessary inference.
What do you say compensation does mean in the proviso?
In my submission, it covers essentially any provision for compensation pursuant to an express provision of the Act, a damages at common law, or a liability embraced by, for example, section 249 with regard to compensation pursuant to criminal prosecution. And in my submission, the word is not being used in any narrow or specific manner when employed here.
Now, apart from section 39, what other provisions provide for compensation?
There are a number, albeit not related necessarily to a breach of the regulations, but there are provisions in the Act for compensation with regard to employees. There are provisions with respect to...
could they be caught by 29.3?
Other than under reference to section 39...
Well, 39 doesn't really fit with 29.
But that's a distinct form of compensation,
absolutely.
I accept.
I mean, what's worrying me is that there does seem to be a question where a statute provides a fine. There's always a question whether that is the exclusive remedy under the statute or it preserves any rights for breach of statutory duty. There doesn't seem to be any doctrine that says that a provision for, say, a criminal penalty excludes any common law right unless it's preserved. Or can exclude.
Or can exclude. On the matter of compensation, though, my Lord, there's also the provisions of section 27, subsection 5, which provide for compensation in respect not of a breach of the regulation per se, but a breach of an order or provisional order made pursuant to the Act.
And where was that again?
Section 27, my Lord.
Yes.
Subsection 5, where a duty is owed by virtue of subsection 4 above to any person, any breach of the duty which causes that person to sustain loss or damage shall be actionable at the suit or instance of that person.
And if 29.3 excluded remedies under those regulations except for the fine, would the 27 proceedings otherwise be caught? In other words, is it necessary to preserve the claim under section 27?
It may not be necessary, my lord. It may very well be, when one looks at the background to this proviso, that it is a case of belt and braces.
Yeah.
In the 1937 regulation, was there anything there about compensation apart from what we saw at the end?
I am not immediately aware of any express provision within the 1937 regulations themselves. Of course, at the time the 1937 regulations were promulgated, there was also the provision of paragraph 76 of the schedule to the 1899 Act, which provided that any penalty imposed for a breach of obligations could be paid to the party who prosecuted that breach. But I'm not immediately aware of any provision within the 1937 regulations, and indeed the form of the regulations follows very much the same line as the 1988 regulations.
Well, maybe your learned junior could while away an idle hour this evening and check to see whether there's any reference to compensation anywhere.
Looking at the index to the 1937 regulations, I cannot see it at the moment.
No, I don't see it down.
But I can't claim to have gone through the body of the regulations in their entirety, my lord. As I indicated this morning, it is far from plain that Parliament intended there to be a right of action, and absent any express provision, one, in my submission, does begin from the assumption that there was no such intention, and then would seek to identify any indicators to the contrary. And far from there being any indicators to the contrary, such indicators as one can properly identify would, in my submission, reaffirm the conclusion arrived at from a plain reading of section 29 itself. And in brief, there is no specific class identified except the general public.
In fact, is there any sort of presumption or any doctrine about interpreting something which gives a regulation making power, which says, for example, that unless it's express, that it doesn't include a power to make regulations which require the payment of compensation, or for example, create a statutory offence, could create an offence. And is there other principles? Is there any doctrine on how one construes a regulation making power?
Well, in my submission, that is reflected in the observations of Lord Brown Wilkinson in the case of X, which we looked at briefly this morning. If I could refer back to that for a moment, Lord. Lord, this allows me a moment to identify the tab number. It's in volume 4 at tab 27.
I remember the passage, but I'm not sure it gives us the answer to the question. Will it?
Well, I wondered if the initial part, I may have misunderstood the question, my lord. But
well, the question simply is, one has got here's a power, and as I understand it, you say we have to look at section 29(3), not at the regulations.
That is what I understand to be the position of the respondents, my lord. And when I put it that way, my lord, there is nothing to be found in the Act, in my submission, nor in the regulations, imposing civil liability for a breach of a provision of the Act or consequent regulations.
I mean, I can think that you could have under these regulations, you could have under this power, you might make regulations where there was no conceivable reason why anybody should ever recover damages and so on. And others where you might think, well, yes, it might be, you know, there would be a possible claim. Now, you can't tell just by looking at that, but I mean, is there a presumption? Is there anything which says, well, a power, if you're going to have a power to make regulations which create offences or which create a liability and damages, it's got to be express, or it's got to be clear that that's what it's saying.
Well, yes, my lord. In my submission, the starting point is that in the absence of express provision, no such liability is created.
Yeah. Surely there must be a part of the ultra vires doctrine that if you have a general power to make regulations to secure that supplies of electricity are regular and effective, that doesn't carry with it the power to impose fines, I would have thought. And there must be an express power, presumably, to impose fines.
So.
Yes. There were general, there were general doctrines in cases like Attorney General and Wilkes United Dairies, I think, cases of that sort about that. I think was more expropriation of property than the imposition of a fine.
But there must be express provision where such a power is to be exercised by way of delegated legislation.
Would it be worthwhile looking at the health and safety legislation? Because some of the health and safety, this is all regulation-making powers, most of it. But sometimes they simply create criminal offences, sometimes they also impose civil liability. It's made pretty clear in the regulations that are made under the health and safety legislation whether or not there is going to be civil liability for breach of those regulations. And I'm wondering whether the Enabling Act actually does, as my Lord is suggesting, expressly give the power to make regulations which will impose civil liability, or has anything helpful about it.
I think there is something helpful about it. My recollection is there is, but I can't quite remember.
But is anybody aware of any general principle that says that a simple regulation-making power in a statute does not carry the power to impose civil liability for breach of the regulations without an express enabling provision? That's the question you're asking, to which I suspect none of us know the answer.
Well, if that is the question, then...
That was the question.
That was the question.
If that is the question, then in my submission, as a matter of principle, one cannot impose that liability by regulation unless there is an express power conferred by Parliament to make regulation to that effect. But there are two distinct situations that
would that apply to? Would that include a power to make criminal provisions?
Whether it be criminal or civil liability, in my submission.
Criminal undoubtedly does need express. Yeah. But
there must be an
query whether civil does.
But there are two distinct situations in my submission. One is where the Act of Parliament expresses a power which can be exercised by the Minister in the making or promulgation of regulations that impose such liability. And that is not the case here, because in my submission there is no such power. And the second situation is where the provision of the Act itself provides for such liability. And my understanding is that the respondents and the Inner House put themselves in the second category of case. There has never been a suggestion that the regulations of themselves can be construed as imposing civil liability, or indeed criminal liability, except as a consequence of the provision in the Act to make regulations in respect of criminal liability. Now, it may be that I'm confusing the issue, but it does respectfully appear to me that there are two distinct situations there. and we're not dealing here with a set of regulations which impose such liabilities. We're dealing here with an act which it is alleged imposes such a liability directly for breach of any consequent regulations that are made. Now, in my submission, one could not do that in regard to criminal liability, and as a matter of principle, I submit that one cannot do that with regard to civil liability. And it is all the more pertinent in situations in which not only the supplier, but indeed the consumer and third parties may be in breach of the relevant regulations. One would expect to find very express provision within the Act for the imposition of such liability, and it is absent.
Yes.
In the absence of any express provision within the Act, the assumption, the starting point, is that no civil liability has been imposed for a breach of the Act or a breach of any regulations made under the Act. And that, in my submission, is reinforced by such indicators as the courts have employed in attempting to construe such statutory provision. For example, the absence of a specific class, the fact that the statutory provision contains its own distinct enforcement mechanism for breach of the statute or of the relevant regulations made under the statute.
Well, I mean, it just so happens that all the regulations here attract the criminal penalty, but the regulation-making power allows you to pick and choose, because it may be any specified provision of the regulation. So you could have some which wouldn't attract criminal penalty, of course. And so that particular argument wouldn't apply to them. But in this, it so happens in this case, all the regulations, all the provisions do attract.
But that, in my submission, it just underlines the peculiar approach of the Inner House and the respondents to the construction of Section 29, subsection 3, and their attempt, in my submission, to invest the proviso in subsection 3 with a meaning it cannot hold on the wording that is there. As my Lord and the Chair observes, the regulations may provide that only some of the regulations, if breached, will give rise to criminal sanction. It may also provide that they will only give rise to criminal sanction if breached in certain specified circumstances. And yet, if we have regard to the way in which the respondents express their position in their case, and if I can take your lordships to that, my lady to that, it's in the core bundle, the respondent's case, just before tab 1. At page 5, and what they say is Parliament used subsection 3, that is of section 29, to empower the Secretary of State to provide sanctions for the contravention of regulations made under section 29, so be it. It is the only subsection which gives the Secretary of State power to provide such sanctions. It empowers him to provide sanctions for contravention of any specified provision of the regulations or for contravention of any specified provision in specified circumstances. It is therefore not any contravention of any regulation made under section 29 which will attract a sanction, but rather a contravention of any specified provision of such regulations or any such contravention in specified circumstances. The Secretary of State has power to decide which specific contravention will attract a criminal sanction. It is only in respect of any such contravention specified as attracting a criminal sanction that civil liability will arise under the proviso. And in my respectful submission, that does appear to be a most extraordinary outcome, that only where the Secretary of State determines that in specified circumstances that a breach of a regulation will give rise to a criminal sanction, will there be any civil liability. And the Secretary of State may, from day to day or from year to year, determine that in particular circumstances a breach of a regulation will or will not give rise to criminal sanction, and accordingly vary the civil liability allegedly arising under this Act accordingly.
Well, you say that's completely contrary to principle, but also, of course, the respondents are led to that by virtue of the fact that they get their claim right to compensation from Section 29(3), which only relates to contravention and criminal sanctions.
Absolutely. My Lord, it's a matter of cart and horse, really. Because that is all they can hold on to, they have to take the consequences of holding on to that and only on to that in order to establish a basis of civil liability. And it's not just that it may depend upon particular circumstances, that it may depend upon particular regulations. It may also depend upon the statutory right to grant exemptions from obtempering the regulations in particular circumstances or in particular cases. And in addition, it would mean that this civil right extends to claiming damages after the event, but confers no right to prevent damage where a breach of the regulations is anticipated or continuing, because it is limited to compensation, namely damages, and confers no right of civil action by way of interdict or declarator or otherwise to deal with a continuing breach of the regulations, which is also a criminal act. And I submit that to try and read all of this into the proviso is to read too much into it. But I also submit that the outcome is, on the face of it, extraordinary, contrary to principle, and is arrived at absent any apparent express provision from Parliament to that effect. And so where is the room for inferring? Where are the indicators that lead one necessarily to that inference? And they're not present. On the contrary, I submit that...
Well, I think it has to be said, well, this you have to look at in the context. This is a safety provision, so like the Factories Acts, really. And then just as they invented this doctrine in the later part of the 19th century to hold that the Parliament intended to provide for civil recovery in circumstances where all they'd actually done was to provide for criminal liability because it's inconvenient to do so. One wonders whether that was sensible, but there we are, that's where we are. And that so one has to say, well, that's this sort of case, health and safety kind of case. You'd expect there to be a right to recover, and the court should simply infer that that's what Parliament must have intended. Because it's some sort of such wishy-washy reasoning which led to the doctrine in the first place.
Well, first of all, my Lord, in regard to health and safety legislation itself, Parliament has made express provision as to when and where civil liability will arise. And that's done by Section 47. Looking more widely at acts for public safety and public utility, one has, for example, Highways Acts, which are clearly for the public benefit and for public utility. But a breach of the provision of the Highways Act does not per se give rise to civil liability. And equally, with regard to utilities, such as the provision of sewers, a breach of an obligation with respect to the provision of sewers does not give rise to civil liability. So, in my respectful submission, the general body of health, safety, utility provision does not lend itself to the implication that if the measure is breached, there must be a private civil right of action. And in that context, in my submission, one has to bear in mind that we're dealing here with legislation in terms of which the supplier has a statutory obligation to supply, albeit subject to certain qualifications. just as the water company has the obligation to allow a party to connect to their sewer, whatever its state and whatever its capacity. And that, in my submission, sounds against any implication that a breach of statute or regulation flowing from that gives rise to a civil remedy without evidence of negligence or nuisance.
Yes.
I'm not entirely sure that I've answered directly the question that my Lord and the Chair posed.
No.
But if I could try and draw together the threads of my position, my Lord, it is that one begins, absent an express provision, with the assumption that there is no intention on the part of Parliament to impose civil liability. Where there is no specific class identified as the beneficiaries except the public at large. Where the other relevant provisions of the Act provide for enforcement of the obligations under the statute. Where Parliament has allowed for exemption from the statutory provisions or regulations made thereunder, and where there is a statutory obligation to engage in or supply the utility referred to. Furthermore, in standing the terms of Regulation 38 of the 1988 regulations, it would be extremely surprising to find that on the basis of Section 29, subsection 3 of the 1989 Act, Parliament had so innovated, the term used by the Inner House, so innovated as to impose civil liability on consumers of electricity.
Yes.
So, in these circumstances, I submit that Section 29, subsection 3 does not lend itself to the plain meaning referred to by the Inner House, and insofar as I need to go further, I submit that there is nothing in the 1988 regulations themselves that could be construed as conferring a right of civil action where a party is in breach of the regulations. And the issue of whether or not the Minister would have had sufficient power under the 1989 Act to make regulations that conferred a civil right of action does not, in my submission, arise in the context of the present case. But my submission would be that if, by way of regulations, the Minister was to impose liability in respect of criminal or civil proceedings, Parliament would have required to make clear and express provision for that in the enabling statute. My Lords, my Lady, in those circumstances, I invite the Court to answer the issue in the affirmative, to recall the interlocutor of the Inner House, to sustain the appellant's first plea in law to the extent of excluding from probation the statutory case pled in Article 6 of condescendence. My Lords, my Lady, unless there are any further matters upon which I might assist the court, I would rest my submissions there.
No, thank you very much indeed.
I would doubt it.
Mr. Barn?
My Lord, my Lady.
Mr. Ivy?
My Lord and Lady, my motion on behalf of the respondents is for the appeal to be dismissed. My Lords and Lady, it is my submission that Parliament's intention to confer civil liability for breaches of certain of the regulations that may be made under Section 29(3) of the 1989 Act is discernible, and that the beneficiary is, from the terms of that section, the public. It is discernible from...
The whole of the public?
I'm sorry, my Lord?
The public?
The public, yes. It is discernible from the terms of the proviso to Section 29(3). The beneficiary being the public is evident from the terms of Section 29(1)(b) and (c), which refers to the specific purpose, one of the specific purposes of the regulations, to protect the public from dangers arising from the generation, distribution, etc. of electric power, and within that generality, the reduction of the risk of personal injury and damage to property.
So it's not just, I think that must be implied, it's not just the consumer whose, for example, whose meter, on whose property the meter is, but of course, as you've got in this case, people next door and so on.
Yes, yes.
Or somebody walking along the road or whatever it happens.
Yes, it could be. Yes. Now, my Lords, if that submission is correct, that Parliament's intention to confer is discernible, then comments on at the end of my learned friend's submission about limited class of individuals benefiting from the imposition of civil liability and other indicators which have been referred to by Lord Brown-Wilkinson in Ex Minors, the search for those and the consideration of those is, in my submission, unnecessary, because the court's ultimate task is to discern what Parliament's intention was from the wording of the particular provisions in question. If that intention is discerned, it would be, in my submission, wrong to remove that meaning simply because a wide class of person was the beneficiary of the...
But isn't that to put the analysis the wrong way round? And that's to start with the conclusion, isn't it? I mean, surely one has to look at each of these factors, including the fact that this is said to be the benefit of not just a limited class of the public, but the whole of the public. Maybe you could put it more narrowly than that. But those are all factors in deciding whether or not, viewed as a whole, there was the relevant intention. Surely that's the right approach.
They are guidelines, in my submission, Lord. They are guidelines, but if, as I hope to convince the court, that the intention can be discerned from the words of Section 29(3) in the context that has been enacted, then one doesn't need to be diverted by the fact that we are dealing with a wide class of benefits.
Does your case depend entirely on the words in the proviso?
Yes, it does.
It does. So, I mean, if there were no such words, or if we were against you on that, on the construction of section 29.3, that would be the end of it, would it?
Yes.
Is that because there are no other indicia pointing towards towards the liability?
It is because that there would be no mention made in the regulations themselves, my lord, conferring such civil liability. The principal act, as I will refer it to, it would be silent on that, and it would leave, in terms of section 29, only criminal sanctions. And as I come to develop the submissions, that would, if I say activate a general rule that where the Parliament has provided for a particular a method of enforcement, then that's the only method via the statute that can be exercised.
Yes.
But, my lords, in my submission, my learned friend made much of the fact that if you start off from the point that, that if a statute does not per se provide civil liability as a remedy, a statutory duty does not per se provide civil liability as a remedy. And I agree that that is the starting point. But it does not go very far along the road, because if a statute creates a duty but is silent thereafter on how someone who is suffers under a breach of that duty should be either compensated or how the breacher of the duty should be penalised, then the implication is that the damnified person has access to the civil courts. So one starts off saying there is no civil liability, but if the statute is silent, there is. If the statute proceeds to provide its own sanction, and the most common is criminal sanctions, and that is the only sanction that's provided, then by implication that is the only remedy under the statute that is available.
Supposing I go into I don't know where it is on my house, but I find whatever this box is, bit of supplier's equipment or whatever, this plant or whatever it's called, and I think it's defective and so on. And I want to bring an action for them to comply with their statutory duty, course session action, I suppose. Do I only do it, can I do that by virtue of the proviso? Or
the proviso in my submission is limiting the civil remedy to that of compensation.
Of damages. So there's no civil right of...
But I hesitate on that because...
Private right.
There may be, as was described by Lord Brown-Wilkinson, such public law remedies of going down the public law route.
Yes, but no private law.
Yeah, under private law, in those circumstances, the aggrieved individual, the aggrieved consumer, would be requiring to go down the statutory routes which have been adumbrated in the Learned
So
Friend.
you couldn't bring an interdict based on private law right, saying I'm afraid that my house is going to be blown up.
Not through the aegis of Section 29.
So what does he do in that situation? He uses the mechanisms in which we saw a bit further on in the Act. It would be open to him to use the remedies under the other parts of the Act to bring it to the attention of loosely referred to officialdom. So it's a private law right to damages or compensate damages in effect.
Yes. So in my submission, the starting point is that if the statute provides a duty but is silent on its enforcement and sanction, then the civil route for the aggrieved party is open to him. And where it confers, or where it provides criminal sanctions, then that is the only sanction that is available to the aggrieved individual. Now, I accept that there are, in some cases, exceptions to that rule, as there always has been. But the rule in my submission puts the wording of the proviso in its context. The proviso is contained purely within the only section dealing with enforcement of the regulations made under section 29. Had there been no 29.3, then we would have had a situation in which the Minister was empowered to make regulations covering a multitude of matters with no apparent remedy available for any breach thereof.
So if you mean by that, do you mean without the proviso to 29?
No, if 29.3 itself was absent, in other words, if there was no 29.3 and all there was a power to make regulations, but nothing appeared, or there was no power to allow for sanctions for breach of those regulations, then the general rule would be that a person damnified by a breach of those regulations would be entitled to raise civil proceedings for damages.
But would that not depend on whether there were other remedies available under the statute?
Yes.
Other means of enforcement?
My lords, what I'm dealing with here are regulations made under Section 29. Section 29 empowers the making of regulations relating to supply and safety.
Yes, but if there was a Section 29, capital A, which said, and in order to enforce this, then you do this, that, and the next
Absolutely.
thing, then you wouldn't enforce. It would be the absence of a criminal sanction plus the absence of any other enforcement mechanism, you would say, then leads on to the
Civil
inference of a civil.
Yes. 29.3 provides for the criminal sanction, and it says regulations under this section may provide that any person who contravenes a specified provision, notice not all provisions, but a specified provision of the regulations, or who does so in specified circumstances, shall be liable on summary conviction, etc. Now, if that had stopped there, in my submission, the pursuers in this case would have had difficulty in maintaining an action for damages for a breach. But what it says is that nothing in this subsection, and that's a subsection making breaches of the regulations criminal, nothing in this subsection shall affect any liability of any such person. And Lord, in my submission, such person must be a person who has contravened a specified provision or in specified circumstances. Any such person to pay compensation in respect of damage or injury. And it is the respondent's submission in this case that damage and injury must relate to damage to property or personal injury in 29(1)(c). Damage or injury which may have been caused by the contravention. And it is narrow, it is within those narrow parameters. And in my submission, it cannot mean that compensation within those parameters means compensation for common law breaches or common law rights. And it cannot mean compensation for, in respect of compensation specially provided for under Section 39 of the Act or regulations made thereunder, or compensation under any other part of the Act. It's compensation for a contravention of regulations made under Section 29. Compensation is not specifically defined, nor are there any special procedures enacted for its recovery. Whereas in other parts of the Act, there are procedures enacted for the recovery of other forms of compensation. And in my submission, within that context, it is clear that what Parliament intended here was that where the Minister has specified regulations, the breach of which attract criminal penalties, then they attract, by virtue of the Act, a liability to pay compensation for personal injury or damage to property which arises as a result of the contravention.
Why would Parliament have limited it in that way? I mean, why would it have only given a right to claim damages in cases where there was a criminal sanction attached?
The reasoning behind it, I don't know. I have tried to find out whether the likes of Hansard can help us, but nothing was said about this addition of this proviso in Section 29. I suspect that it has its origins in the same phraseology, or almost the same phraseology, featuring in the earlier enactments.
I think that seems very clear.
Where the recovery of a penalty shall not affect any liability for compensation, etc.
Well, your difficulty to my mind is that the language doesn't impose the liability.
No.
I mean, you're construing as if it read, and shall be liable in respect of any damage or injury which may have been caused. Whereas it doesn't say that. It says, but nothing in the section shall affect any liability. Yeah. I mean, what I don't quite understand is how you say that what appears to be a proviso is in fact creating a right. It's almost impossible, isn't it, to get it out of the language.
You premise it, as I understand it, on your proposition that if statute provides a duty but no sanction, the private law remedy is always available. Yes. That is your premise. And you say that this proviso, and normally that is taken away by the provision of criminal penalties, but the proviso saves the general rule.
That is the context.
Well, that would be all right if it weren't for the fact that the section itself provides for the fine.
No.
But it is within that context that I submit that 29.3, in its reservation language, can be read to mean that civil, or has to be read to mean that civil liability for breaches of specified provisions is available for damage, for personal injury and for damage to property.
I thought a few minutes ago, because I asked you, I thought that your position was that it was only the proviso which pointed to the liability created, because I asked you whether there was, if we took it away, one would find other indicia which would point to liability. And I thought you said no. I may be wrong, but I think Lady Hill's starting point is, I think, that if one looked at that you were starting from the position that there would be, you could find liability, but if you suddenly put in a criminal sanction, the liability would disappear, and then you put this back in to keep the liability. But I thought a little while ago you said to me it was only this bit which pointed to liability.
Perhaps it was I didn't express it clearly enough, my lord. If there is no sanction at all provided for breaches of these regulations made under 29, then my position is that the civil liability would be available a civil remedy would be available and civil liability for damages would be present. But if there is an inclusion of a criminal sanction, then by virtue of the general rule, which is outlined in the appellant's case, that option would not be open.
You have a perfectly clear line of reasoning, which I think I understood when I put it to you, and I think you agreed with me, which is you start from the proposition that if statute creates a duty but gives no remedy for breach, then there is always a civil remedy available. That's your starting position.
Yes.
But if there is a criminal remedy then provided in the statute, that takes away the civil remedy there would otherwise be. But if, of course, you have a proviso like this proviso, it puts it back. That's your process of reasoning. And my problem with that process of reasoning is that I don't understand the law to be as your premise.
There can be circumstances in which the criminal sanction is provided, but by virtue of other indicia, the court has concluded that there is also civil sanction.
That, of course, we all know because of the Factories Act cases.
Yes.
But the initiating premise that without any provision for a sanction, there is always civil liability, runs directly counter to quite a lot of quite high authority.
Well, my lady, it's what I took from the Viscount Simmons in Cutler, which is to be found in volume 3 of the documents. Tab 5.
If the statute provides no remedy for its breach and there is an intention to protect a limited class,
Exactly.
that is an indication that Parliament intended a civil action.
Cutler and Wandsworth Stadium.
That comes from, well, it's the Cutler line, but it's in X, I think, too.
Well, my lords, in Cutler, if I can refer to Cutler,
Sorry, Mr. I missed it. 5. What was
it's
it?
volume 3,
3.
tab 5.
3. Yes.
At page 407 of the case report. From the second paragraph, which is the dictum oft quoted, my lords, in my opinion, the judgment of the Court of Appeal was clearly right. I think it is true that it is often a difficult question whether a statutory obligation is placed on A, B, who conceives himself to be damnified by A's breach of it, has a right of action against him, but in the present case I cannot entertain any doubt. I do not propose to try to formulate any rules by reference to which such a question can infallibly be answered. The only rule which in all the circumstances is valid is that the answer must depend upon a consideration of the whole Act and the circumstances, including the pre-existing law in which it was enacted. But there are indications which point with more or less force to one answer or the other is clear from the authorities, which even where they do not bind will have great weight with the House. For instance, if a statutory duty is prescribed but no remedy by way of penalty or otherwise for breaches imposed, it can be assumed that right of civil action accrues to the person who is damnified by the breach. For if it were not so, the statute would be but a pious aspiration. But where an act, and I now cite from Lord Tenterden in Doe versus Bridges, creates an obligation and enforces the performance in a specified manner, we take it to be a general rule that performance cannot be enforced in any other manner. The passage was cited by approval in Passmore versus Oswald Bristol Urban District Council.
But in X, Lord Brown-Wilkinson makes it clear that that's part of a series of decisions about a limited class.
Yeah. And you get that on the next page here, citation from Lord Kinnear and Black and Fife Coal Company, just about 10 lines on to page 408. Duty of this kind is imposed for the benefit of particular persons.
Well, my lord, if a statute makes it plain that the public is to be the beneficiary, then in my submission, the intention can be gleaned from such provisions that enable the public to be the beneficiary, and that.
Now, what's the authority for that?
Well, my lord, that is why I take from the Cutler line, that one is trying to discern the intention of Parliament from the provisions it's enacted, and given the creation of the ability to make regulations for safety, the fact that the remedy is to be by criminal sanction.
It's not just, I mean, some of these regulations have been, I mean, there's actually, in the regulations, there's a means of enforcing them, isn't there? Regulation 38
yes.
contains
a
mechanism.
Within the regulations, there are those regulations which, if I can call it, that are anticipatory, and within the Act, such as section 25 and 27, where there is a breach or an anticipated breach, and by notice through the provisions within the Act, it can be brought to the attention of the consumer or the supplier or otherwise, and he is given a certain amount of time to sort things. One would always want regulations to work, but there are occasions when regulations don't, and fuse boxes at the cable head start fires, or equipment blows up. The time for giving notices is passed by then, and the specific enforcement procedures for the likes of notices is passed by then, and people have suffered injury or damage to property. What I take from 29.3 is that if you have a regulation the breach of which attracts a criminal liability, and the breach of which has caused personal injury or damage to property, then the person suffering that injury or damage to property can have the right to compensation. It's not every breach, and it's not to every regulation. It happens to be that the 1988 regulations, and indeed I think the 2002 following regulations, all of them have been declared to carry criminal penalties in some way, shape or form.
But if your premise is right, then all those breaches that did not give rise to criminal penalties would give rise to civil liability. If your premise is right, they all would. And that is not your case. You expressly disavowed that case.
The effect of the proviso is to limit those occasions in which damages for personal injury or damage to property will be available. One is looking at it from the obverse. In my submission, the wording of section 29.3 cannot mean that all it's saying is that common law is preserved. From the submissions of my learned friend this morning in dealing with Herd, Rowe and Stevens, the conclusion appears to be that without the proviso in section 29.3, the pursuers wouldn't even have common law open to them. Now, it wasn't their position, certainly at first instance or before the Inner House, that would have been the case. Otherwise, they would have been seeking dismissal of the whole action. The common law provisions in my submission stand alone. If negligence can be established with then the remedy under common law is available. It cannot, the compensation envisaged as being reserved cannot be common law compensation. Nor, as I said at the outset, can it be compensation under some other section of the Act. It it is very specifically put into a subsection of 29.3, a subsection of section 29 of the Act, which itself only deals with the provision of regulations in respect of supply and safety. Now, the supply and safety have been combined in the historical development of regulations under the Electricity Acts. They have been combined, and they appear to have been combined in the 1937 regulations. Before that, they were split, or they were separate. There was a separate set of regulations for the continuance of supply, the proper supply, and there were regulations in respect of safety. And this proviso, or words like it, appeared only in the regulations in respect of safety. Mrs. Stevens didn't have a right of action under the statute, and it was conceded by her counsel that that was the case. What she sought was common law under the supply aspects of the regulations then in force, and she was told she didn't have any. If she had been injured by her permanent waving machine going on fire or blowing up, then different considerations may have applied in Stevens, because that she would be enforcing the safety regulations, which carried words closely related to the proviso.
Mr. Ivey, I wonder whether could we just break for 5 minutes?
Sure.
Yes, Thank you. I apologise, Mr. Ivor.
My Lord, I'd said that initially the safety regulations were separate from the regulations enjoining proper and sufficient supply of electrical power. They were combined in the 1937 regulations into one body, but as has been made evident to the court, the words of the proviso or proviso-like words found themselves into Regulation 39 of the 1937 regulations, and that was what was considered by the Court of Appeal in Herd, which has been, Ladyship have been referred to this morning. That's in Volume 5, Document 7, Tab 7.
Yes?
And Herd concluded that a breach of the 1937 regulations attracted specific civil liability because a default under Regulation 39 thereof was the same default that was referred to in the paragraph, I think, 77 of the 1899 Lighting Clauses Act.
That seems to have been a point taken by Lord Justice Tucker in the course of the argument. One looks at near the top of page 696.
Yes, it was recorded as during the submissions. Now, it was suggested that in somehow Herd stood contrary or in contradistinction to the decision in Roe, and in my submission it doesn't. Roe dealt with a similar provisions as to the schedule, or paragraph 77 of the Lighting Clauses Act schedule. But it didn't deal, as far as my reading of the case report, it didn't deal with any regulation thereunder referring to act or default. And my reading of Roe, in my submission, what Roe said was that the section 55 of the particular act didn't on its own afford the complainers a statutory route to damages, but if there had been other provisions that afforded that route, then they would have their statutory remedy. And as my understanding and reading of Roe, there was such other provisions, and they did get their statutory remedy. Now, that doesn't clash with Herd, because Herd had the responsibility for accidents, defaults, and such like provisions, and also the regulations saying that, under Regulation 39, that breach of the regulations was a default. In my submission, what we're dealing with here is very similar. We have under section 29(3) a contravention of the regulations made thereunder, and also in terms of the 1988 regulations themselves, under Regulation 39, to which your Lordships and Ladyship were taken this morning, a failure to comply. Now, it doesn't say contravention, but in my submission, excuse me, reading 29(3, with Regulation 39, the failure to comply must mean the contravention, because they both point to the offences under the Principal Acts. So one is driven to the same comment, does a contravention under 29 not mean the same contravention that attracts the offence under Regulation 39? And in respect of that contravention, compensation is envisaged to have been reserved. And my submission heard was...
So where do you say the right to compensation comes from?
It comes from that reservation, Lord. That's what I'm saying.
Something which reserves a right creates it. Is that what you're saying? I would have thought a reservation was something
Well,
which...
I would say Parliament operates in weird and wonderful ways, but in my submission, that's the wording they chose, and when one is trying to give meaning to that wording, that is what, in my submission, it means.
I mean, you might just have thought that it was saying, well, the fact that it's a criminal, you get criminal sanctions and you have to pay a fine doesn't affect any liability which you may be under to pay compensation for damages.
For damages for personal injury or damage to property caused by the contravention, not caused by negligence or caused by behaviour which is different from the original the behaviour that brought about the original contravention.
Negligence may cause the contravention. I mean, it may.
It may not, or there may be no negligence.
But you're relying on exactly the same act, whether you're calling it negligence or breach of the regulation.
I think that the case of negligence is a case of vicarious liability by the inadequate fitting of the fuse by the employees of the defenders.
Well, I take it you must have several. Do you not? Have you not got you've got no case, for example, based on the equivalent of inspection or something, failure to inspect?
No, my lords.
No,
it is the shim. The shim was there, and the position of the pursuers here is that was put in wrongly by the and negligently by the employees of the Scottish Power.
Well, fortunately, if you're right about that, you'll win, won't you?
Oh yes, and equally, my lord.
Presumably, this is a battle between the insurers, is it? In this case, that's probably an irrelevant consideration.
Equally, my lord, if the defenders are correct in their reliance on reasonable practicability, which is available to them under each of the regulations that the pursuers rely on here, and they rely on that defence of reasonable practicability because their explanation for the shim being in place was it was us that put it in, they win. I mean, they don't need to worry about whether there's any...
So it's all about where the burden of proof is, then?
It might well be, yes. But we have not yet found out whether this... Well, I think everybody accepts that the shim was there. We certainly haven't found out how it got there. That is the interesting question which we haven't yet reached in 5 years of litigation.
The next decade's activity.
Yes. Yes.
I should say that, lest there be any clouding of what happened here, the equipment that is being criticised by the pursuers is a fuse holder. It is not in what Lord Roger described as a fuse box, if I am taking it. It is at the cable head. Yeah. It is downstream of the fuse box, which I now understand to be known as a consumer unit. It is downstream of the fuse box, it's downstream of the meter. It was a fuse at the cable head which protects the meter and everything after it from major increases in power. And it was that fuse which was found to have an improperly repaired prongs, or a shim was put on it.
Yes?
Now, my lords, my learned friend spent some time on the exclusions, ability to exclude liability and negligence for economic loss under Section 21 of the 1989 Act with reference to A.E. Beckett. My lords, in my submission that there is no interference with what I submit as the meaning of Section 29.3 and the operation of that section. There is no illogicality or illogic in saying that you can exclude economic loss for arising out of negligence should there be an interruption in your supply, but if that interruption has resulted from a breach of the regulations which has attracted a criminal sanction, or which would attract a criminal sanction, it appears not illogical that the same clause would not exclude liability for compensation in those circumstances. Beckett, in the appeal court decision, which is at volume 3, tab 1, second part after the blue divide, when the court there asked for further investigation into what economic loss might mean, namely, was it pure economic loss or was it something else? There was a further written submission which made reference to Hansard volumes, and that can be seen at the page 290 of the Court of Appeal case report. The Hansard sections are quoted in paragraphs 34, 36 and 37. Essentially, the court took from that pure economic loss was not in the mind of the Parliament when it enacted 21B, but it also, in my submission, 21.2b, it was also in my submission significant that at the top of, or in paragraph 37, the court notes that in the House of Lords, the government spokesman, Lord Sanderson of Bowden, explained that clause 21.2b was introduced in recognition of the fact, that is the exclusion of liability, that in a few instances the loss of supply of electricity for a very short period of time could result in substantial economic loss without there being any accompanying physical loss. The economic loss in such cases could well exceed the value of the supply lost. I'm sorry, my lords, I got confused there. It was not the passage I was intending to read out. It was those at 36. I do apologise. At the outset, Mr. Spicer, who I think was the sponsoring minister, made it plain that the provision which became 21A was also aimed at permitting restrictions imposed on the supply of current. The first of the contexts in which additional terms of supply will be permitted is in respect of safety. At present, the bill does not allow the supplier to impose the restrictions necessary to allow him to comply with safety regulations. That could give rise to a potential anomaly. The supplier could be obliged to provide a supply under clause 15. I think that now became section 16 of the Act as enacted. Although in doing so, he would contravene the requirements of the regulations made under clause 27, now 29, on safety, The new clause would therefore give the supplier the right to impose restrictions in supply where necessary to enable him to comply with those safety regulations. So this element of excluding liability, restricting the supply of power, was to enable compliance with the safety regulations. And with that in mind, my lords, in my submission, it is not illogical to find that if such safety regulations are breached, if there is consequent personal injury or damage to property, then the exclusion of liability clauses which may be included in the supply of electricity would not be applicable to prevent damages being paid. The other sections which my learned friend dealt with are sections 25 and 27 and 45 and 46. And in my
I think the Dean's point, as I understood, was that, what's the point of 21B allowing them to restrict any liability for economic loss resulting from negligence if he would be that would leave the supplier exposed still to damages for breach of statutory duty?
Well, in my submission, if the event which would activate the exclusion of liability was also, in fact, a breach of the regulations, then there is no illogicality in saying that the exclusion of liability would not be effective. There could be many other instances in which the exclusion of liability would be effective, where an interruption in supply would not, in fact, be a breach of any of the regulations. And it's not entirely clear from my reading of the regulations of 1988 that there are any in which would result in in an interruption of supply simpliciter. It's usually associated with an interruption of supply as a result of machinery breaking down, things blowing up, machinery not being suitable, plant not being suitable. There is certainly a lot of scope for the effective exclusion of liability clauses under 21B that do not necessarily result or are not necessarily activated by any action which has also been a breach of the regulations. There is one a regulation which I should bring to the attention of the court, which may, on reading of it, suggest that a simple interruption in supply would be a breach of the regulations, and that is Regulation 32, as originally enacted. It's in the 1988 regulations, Volume 2, Tab 13, page 18, as written, handwritten in the top corners. The Regulation 32 is headed Electricity Boards to provide constant supply, and from time to time, when any electricity board begins to supply, it shall, unless otherwise agreed with the consumer, maintain the supply. Now, that could, in its terms, be apt to allow for a breach resulting in an interruption of supply simpliciter. But that regulation did not survive the coming into force of the 1989 Electricity Act. When the 1989 Act came into force, there was also an immediate amendment of the then 1988 regulations. And those amendments are found now in the 1990 regulation, Electricity Supply Amendment Regulations 1990. Initially, those can be found at
Tab 14.
There's no
yes, 14 only going some of the way. Unfortunately, they didn't provide they didn't print the schedule giving the amendments, but that schedule is now available in volume 5. Tab 5. The 1990 amendment regulations came into force, as by one can see from 214, came into force on the 31st of March 1990, which was the time when the 1989 Act came into force. And they removed Regulation 32.
But isn't it legitimate to take it into account when considering whether Section 29.3 was really intended to provide a private cause of action?
It didn't survive, if I can call it. There was no Regulation 32 when the proviso came into force. It was immediately, it was amended immediately. It never survived what 29.3. What it became was in paragraph 10 of that schedule in volume 5, tab 5, interruptions of supply. Any public electricity supplier may discontinue supply for the purposes of testing, provided that the supply shall be discontinued only for such period as may be necessary, and on giving 2 days' notice. Now, that is an entirely different circumstances to a simple interruption of supply. That's where the electricity supplier decides to cut you off. And in the circumstances, if they haven't complied with the regulations regarding notice, etc., then it's hardly surprising that there would be.
I'm not sure I quite grasp the difference between the two.
Well, the one simply says maintain a constant supply. That was the original 32.
They also can say well, the supply may be discontinued.
But it's the other one is concentrating purely on discontinuance, which is a deliberate turning off. It's not just an interruption of supply simpliciter. They've decided to turn off the power.
Yeah.
I don't think I've quite grasped the significance at this point.
Well, Lords, I was dealing with the Beckett situation in which it has been suggested that if there could be a breach of a regulation which brings about a situation in which an exclusion clause under 21B would be subverted. And what I'm saying is it's not apparent from any of the regulations that that set of circumstances could come about. The only one which suggested that it might come about was Regulation 32 in its original form, which did not survive the coming into force of the 1989 Act. The Dean of Faculty dealt with sections 25 and 27, which were the orders, final orders and provisional orders, and 45 and 46, which were investigation matters. All of those relate to very specific instances. They all relate to relevant conditions and relevant requirements, and those are specifically defined in the 1989 Act.
So, I'm not sure that I've got it. 21B. I mean, supposing that for some reason I was able to say that I supply some high-value factory or something, and I say, well, I want to exclude my liability for damage caused by a fire, caused by some bit of my equipment on the premises. Do you say that's not covered by that?
If fire was as a result of a breach of a regulation, yes, any exclusion clause would not be effective. There could be access to damages through breaches of a regulation.
So you can have that. So in other words, I could exclude my liability for economic loss due to fire caused by negligence. Is that right?
Your Lordship might bear with me.
21B.
Unless it was also a breach of the
Yeah.
regulations.
But if it was a breach of the regulations, I would be stuck, wouldn't I? But it's simultaneously. So my works are got to be suitable for their purpose. They're not, it causes a fire. Let's say they're not because of my negligence, but it's a breach. It would still be a breach, I would think, of section 20, of regulation 25.
Well, the two questions would arise, or one question would arise, was whether under 21B it would be decided that that type of attempt to exclude liability was reasonable in all the circumstances for the person
Well, we have to
accept.
assume that it is thought to be. I mean, we've got to assume that it was. I mean,
Well, my submission, if the fire arose as a result of the breach of the breach of the regulations, then the exclusion clause would not be effective.
so it would be it would be effective only as regards negligence, but not.
Not in respect of the breach.
Even if it was a negligent breach, but it would be by
Yeah.
ex hypothesi a negligent breach.
Yes, I mean, if it's a breach and there has been that result of damage to property or personal injury.
So you can exclude liability for negligent breach, but not for innocent breach.
No, if it's a negligent breach, it's still a breach, my lord. I mean, if it is a breach
The
of the
difficulty with that, though,
regulations,
is you have to put in brackets, don't you, after negligence, unless also a breach of the regulation. Otherwise, one might have thought the negligence would include a negligent breach of the regulations, because it would just be a type of negligence. Or an instance of the negligence.
if there was, I mean, if the person suffering the damage or injury can show that it arose as a result of a breach of the regulations, then he would have a remedy through that route, irrespective of an exclusion of liability clause. And as I say, I don't think, in my submission, that is not illogical.
As Lord Collins says, it's really very odd. You can exclude for negligent breach, but not for innocent breach. And you exclude for negligence, but not for an innocent breach.
You can exclude from negligence, but not from an innocent breach. Yes, that would be the result. If it's a breach, if it's a breach of a regulation which carries with it the criminal penalty.
And if it's also negligence, then it wouldn't be excluded on the true construction of Regulation 21B. That's your point, isn't it?
Well, there would be a remedy via the breach of the regulation to obtain damages, which would not be excluded by regulation, by any exclusion provisions under 21B.
Could there ever be, I mean, going back to 16.1, which is what 21 is about, could there ever be a liability for negligence which wasn't also a breach of the regulations?
Well, that's what I tried to demonstrate with looking at the regulations as they originally were. Almost all the regulations have a stringent test, and it usually, almost exclusively, involves there being something else. There being a failure of equipment. There being an unsuitability of equipment.
But how could an electricity supplier be guilty of negligence except in relation to those matters? Given that 16.1 is about supply and providing electric lines or electrical plant.
there could be negligence in interrupting supply by virtue of switching. There could be negligence in a decision, a negligent decision to restrict or interrupt supply in a ill-fated attempt at trying to comply with the regulations. None of these would necessarily mean there was a breach of the regulations. Now, my Lords, as I had indicated, my learned friend brought to your Lordship's and Ladyship's attention orders for securing compliance under Section 25. But that, again, is quite a restricted circumstances that's governed by that section. The section refers to orders securing compliance with relevant conditions or relevant requirements, and they are given a definition under section 25.8. A relevant condition, it means a condition of the licence, and a relevant requirement, I'm looking at the 1989 Act as originally enacted, Volume 1, Tab 5. A relevant requirement is the requirements imposed under Sections 9 or 16 to 23 above, which is the requirement to comply with a request to connect power, as opposed to the safety of the power so connected. Now, the relevant requirements were expanded considerably as the 1989 Act developed, and 25.8 now covers other statutory provisions. That's to be found at Volume 3, Tab 6, page 45. Relevant condition still remains a condition of the licence. And relevant requirement still means the requirements under sections 9 or 16 to 23, but now includes a whole lot of requirements under section 32. Those requirements are in relation to the requirement of each electricity generator to use renewables. As far as I can see, to use renewables, and the whole section of 32 is to deal with renewable obligations, or renewables obligations.
They're not going to help us.
They're not going to help us, no. Neither does section 40, 48, or the remainder. They deal with overall performance standards, directors' remuneration, competition functions, and charges levied on disadvantaged persons. And the Consumer Estate Agents and Redress Act deals with the setting up of the National Consumers Council, and most of the requirements under there are to give information or to comply with requests made by the National Consumers Council. So it is not apparent in my submission that enforcement proceedings under Section 25 have any relevance to breaches of safety regulations under Section 29. Sections 45 and 46 revert to the same relevant requirements or relevant conditions. Those are the investigative matters mentioned in those sections. Enforcement matters in those sections. Enforcement matters is the matters which the functions of the Director under Section 25 may be exercisable. One goes back to 25.8, the definition of relevant conditions or relevant requirement.
Yes?
25 is also what I would describe as also anticipatory in its functions. It allows the Director General, as originally enacted, to, or the Secretary of State is originally enacted, to anticipate where either a breach, or either there is a breach of a relevant condition or relevant requirement, or there's likely to be a breach, and for him to act in anticipation of potential trouble and to serve the notice procedure on the parties whom he has in his sights. That is entirely different to a situation where everything has happened. And,
we're surely concerned with the mechanism which would apply to regulations made under Section 29.
Exactly, yes, my lord.
And that mechanism is, for better or for worse, one of the mechanisms is the anticipatory one, but it comes further on, 39 or something like that. 38, isn't it?
What I am saying just now, my lord, is that if it, as I understand Millennium Friends submissions, there's something incongruous about the provisions of Section 25 and breaches of the regulations which would allow people to sue for damages. And in my submission, that is not. There is no incongruity between those two provisions. And the same anticipatory action is what is envisaged in Regulation 38 of the 1988 regulations, where there's notice procedure, and it's on the Secretary of State is satisfied that, and it was emphasised, a part of a consumer's installation is or is liable to become a source of danger or interfere with a supply to others. The Secretary of State may give notice asking that particular person to do something about it, and that person, if he disagrees with the notice, has a certain amount of time to do to challenge that notice. That is not in. It does not make, that can fit perfectly well with a situation where everything has happened and there has been a breach of the regulations resulting in damage. And if one is looking at a breach of 38.1, then the breach of a breach of Regulation 38, the breach of Regulation 38 arises when you've received your notice and you've ignored it. You haven't challenged it, but you've ignored it. And you haven't made dead the power, removed the equipment, or continue to use it. Again, there is no, in my submission, no incongruity there.
It does mean that a consumer could be found liable in damages for
It does
strictness.
mean yes. If the consumer commits an offence, if the regulation provides for the consumer committing an offence, yes.
The regulations they do provide for
Yes,
that?
they do. Yes,
Yes.
some of them do. Yeah.
What do you say about Section 27, subsections 4 and 5? I recognise that these are about a different type of duty, but what's striking about them is that in this very statute, if Parliament had wished to spell out the duty, that a duty was owed by A to B, a breach of which was to be actionable at the suit or instance of another, then there we have language entirely apt for that in subsections 4 and 5.
Yes. Yes.
And it is perhaps striking that that's what Parliament really intended. It only did so in the rather obscure way of adding it by way of some sort of proviso to section 29.3.
I accept that there is a difference in language there, but I stand by my submission as to what 29.3 means, Lord. My Lords, there is little more that I can add to the submissions, and my motion, as I indicated at the outset, is to dismiss the appeal and leave the inner house interlocutor standing.
Thank you very much indeed, Mr. Harvey. Mr. Stewart,
My Lords and Lady, I have nothing to add.
Dean of Faculty.
The Lord and the Chair had raised the question of whether the 1937 regulations contain any reference to compensation other than the reference that appears in Regulation 39 itself. I believe there is no further reference to compensation, and I take vicarious responsibility for that analysis of the regulation.
Mr. Barn can have a quiet evening, is that?
Can I just ask you a question which is related? I notice in tab 2 of volume 5 there is the Electric Lighting Act 1882, which is probably the first of the acts which are contained in the sort of compendious Electricity Supply Acts 1882 to 1936, under which the regulations were made. And section 17 of that.
Davis, I've missed it.
Did you notice
Wait,
that?
no, which?
This is in
5.2.
This may be a terribly unfair question,
5.2.
and no doubt somebody will tell me if it is. But it's tab 2 of
Yeah.
volume 5, and it's the 1882 Act. And this contains, in section 17, in the exercise of the powers in relation to the execution of works given them under this Act, or any licence, order or special act, the undertakers shall cause as little detriment and inconvenience and do as little damage as may be, and shall make full compensation to all bodies and persons interested for all damage sustained by them by reason or in consequence of the exercise of such powers. The amount to be determined by arbitration. That looks awfully like section 55 of the Tramways Act. But I wonder how long that remained in force, and whether it was in force when the 37 regulations were made, and whether that has therefore got some explanation for, I don't mean the 37 regulations, yes I do, both the bit in paragraph 77 of the schedule to the Clauses Act, and also the bit in regulation 39 of the 37 regulations.
My Lady, I'm not able to say immediately when section 17 was repealed, although I don't believe it survived until the 1989 Act. But clearly, I wonder if my Lady will allow me a moment.
Well, it was certainly still, it looks as if it was still going at the time of 1937, supply regulations.
It does seem to be a provision, my Lady, which is directed to the opening up and construction of works required for the provision and supply of electricity, as distinct from those works required for the maintenance of a grid system and a distribution system.
That may be so. That may be so. It may be something that's just worthwhile going away and thinking about and
Yes, I mean,
sending us a
We
note.
we would be content to submit a note to your lordships and milady once we've determined when and in what circumstances section 17 was repealed. But I regret that as I stand here, I'm not in a position to answer that inquiry, milady.
Mr. Ivey, you would do the same. You would look at the point.
I understand that there was a number of amendments repealing and alterations to the 1882 Act and the 1947 Act, the Nationalisation Act. The remainder of the 1882 Act was undoubtedly got rid of by the 1989 Act, but it was certainly extant and live in 1947 and remained live to some
I
extent.
think if we could get a note on that, then
We shall do that,
yeah.
milady.
It would be very helpful because we're looking at what on earth this archaeology reveals about what this proviso was aimed at. And so the underlying statutory provisions would obviously be of some help.
Lord, we shall address that. Unless there's any further matter, my lord.
Well, thank you very much, Dean Faculty. We're very, very grateful indeed to council on both sides for their submissions in writing, as well as orally, on for the archaeology which has been revealed to us, and we shall take time to consider our decision on that.